it is you going to the High Court, you do have to regulate your mind that you're going to wait a while before you get a hearing date. There are a lot of things that has to happen before a hearing date as well. Unless you file a fixed date claim form. Once you file a matter like that in the High Court, you have to serve it, you have to do affidavit of service, you have to give time for defense before the court can appoint a time for you to come before it.
And so, 𝗚𝗏, in answering this client's question, I know that we did plan, in fact, and we are trying to answer the questions, but we did have a plan for this webinar because it is very near and dear to me. No, because that members of the public understand the magnitude of the work involved in preparing documents for court. I mean, even today we had a run for our money, right, and filing a document. And so hearing a member of the public, and this is in no way attacking her, we love your contribution, we're grateful for it, but it helps us understand the minds of the public and how they feel about work being done within a legal fraternity. She literally said that the court is on holidays. And I mean, that is a term that, though we may chuckle about it, it is very serious if you go away with that misconception, you know. So for instance, and I want to walk through in the civil arena and take you guys through the process of how things are to be handled. Let's say in her same situation here, where let's say you would have applied for injunctive relief against this tenant, right? An injunction, we went through injunctions before. Not saying that this is how you deal with the situation at all, but I'm just giving an example here. There's a process and procedure required. You have to file your statement of case. And along with those documents are several other documents that are often very, very lengthy that had to have a particular format as well. What is claimed there or pleaded there or explained there or stated, let me use the word stated, right? When you're looking, for example, for filing for an injunction, you need to not only have all the paragraph explaining your case, but description and exhibits of everything that you are saying. Exhibits mean whatever documents you are speaking of, and I mean every single document you reference and mention has to be included in what you submit and marked. Oftentimes as well, if memory serves me correctly, usually for an injunction, there's the affidavit in support as well, which is done in the client's voice, that needs to be commissioned by a commissioner of affidavits. And all of these have to be correctly labeled. Let me use those words instead of exhibited. It has to be labeled properly. It has to be sworn to and signed, each and every one of those. Then often you have to also prepare a certificate of urgency, asking the court that this is really an urgent matter, and these kinds of things. You also have to file, I try to remember everything for an injunction. So an injunction alone has a series of documents that your attorney will have to prepare in a very particular and precise manner. It's not just a story that they submit to the court. It's a group of documents that all have specific requirements according to the rules, right? And need to be filed in a timely manner. Now, if you are also, you have another party involved in this and they can reply to what is being said. Time needs to be allotted for that, not because you would have made a claim against another person means that it is final. Sometimes a lot of people believe that once I come to my lawyers and I start proceedings and I file and I pay my money, I am guaranteed to be successful and injunctive relief is owed to me. I paid my money. I want to get my injunction. That is not how that. Yeah.
That's interesting. Again, and so these are navigating the courts, and as a non-legal mind, the information so far has been such. I mean, a non-legal mind who works in a legal space, I now appreciate that there's a lot that we don't know. Now, we knew that we don't know, but there's still so much that we should know, like just the basics, just understanding the terminologies. Those are things that we should know Trinidad and Tobago, because knowing these things helps you when the lawyers are talking to the other lawyers or the judges or anything like that. It gives you education to be able to even save your own self, right? So let's look at Lisa. Lisa says, therefore, the matter of the three accused with extortion recently, and one pleaded guilty and was sentenced, the other two not guilty, nothing guilty, then the two still stand a chance of being acquitted.
They stand a chance of being acquitted. They also stand a chance of being guilty. Not because that one person pleaded guilty means that the other two are not guilty. If this question is from Lisa.
Yes, Lisa.
Yes, so Lisa, it means therefore that the persons would have entered a plea of not guilty, and the matter has to go to trial. This can take 2-5 years. It will take a while because there's a lot of things that has to happen before it gets to the trial stage. There's a lot of case management, so they also have that hurdle to achieve. Now, it is always for the prosecutor or the police, whether it be the police himself or whether it be a state prosecutor, legal counsel from the DPP's office. It is for them to prove those allegations. It's not for you to refute that you didn't do it. It's for them to prove that you did. So in so doing, they are the ones who will do the legwork in terms of getting witness statements. They would have to serve those witness statements. The attorney has to look at them. The attorney has to see whether or not there's evidential objections. For example, if the statement says, well, Jean tell me that Tom say that she get extorted, that's hearsay, and that cannot fly. So the attorney would object to that, and it will be struck out. And there are a lot of things that the processes that have to be followed before we get to somebody taking the stand.
Wow.
I'm seeing the comment section is lit with a lot of very interesting additions. One of the things I wanted to address very quickly is one of the last questions, and of course I know Mr. Paul will go in order. Some of the comments we should ignore completely, like the ones that include guns and cutlasses. But anyway, now where can I ask a question, because I also wanted to address it. We spoke about it here a couple of BTUs ago. BTUs for us means a Bring to Understanding meeting where all the attorneys come together at the firm and discuss matters. People often think that Trinidad and Tobago is a bailiff could come and put out people, right? Just like that. Please desist or abandon that misconception. Licensed bailiff, first of all, they have to be licensed bailiff, and they can only act, or should, and let me use the word should because we're in Trinidad and Tobago. Should and can only lawfully act with court order. So a police officer or a bailiff cannot get involved in civil proceedings. And a tenant not wanting to come out of a house is not a criminal matter yet, right? Unless you use something else. But ordinarily, a bailiff is not and cannot lawfully and arbitrarily. Although I'm not saying that it does not happen, I am very aware, being in the property law arena, that it happens, but it is not the lawful manner in which to go about these things. And someone may ask, well, why should I care if the bailiff willing to do it and I'm willing to pay my $3,000 to go and ting up the place? Why not do it? Well, if in the event that tenant, now oftentimes in Trinidad and Tobago, the tenant is equally ignorant of their rights, right? And they may believe, I got put out already. And if they don't have money to pay rent, they don't have money to carry it to court. I mean, that may be the thing as well. Right? But it doesn't make it right, and it doesn't prevent them or a relative of theirs who do know the law from bringing an action against you. And so, you come to the court now as the landlord, and many landlords, is another thing in property law. Many of you have no tenancy agreement. It's on a lot of, verbal and all of that. And if you do have it, you are not really the landlord. You are really you are not the owner of the property. So you really don't have no locus. So you're making yourself worse because it's really your grandmother, cousin have the deed for the house. but you tell the person to come and live there, and you get them and you get a bailiff to put them out. So you have to recognize and remember, not because a civil wrong has been done to you. We're not saying that the tenant isn't delinquent. We're not saying that the tenant isn't overstaying their welcome and that you should have redress made available to you by the law. You are absolutely in rights of that. We're saying please go through it the proper way and use due process so that you do not become equally prejudice yourself against justice.